Honors, the matter before the court this morning is the case entitled Elizabeth McCurley versus Tyler LeBeau, case number 25 AP 090. Appellant Tyler LeBeau is self-represented. Representing the appellee, Elizabeth McCurley, is attorney Justin Scoville.
Does the Mr. LeBeau, Mrs. Scurll, do you understand that we had some problems with WebEx yesterday? We think it's all resolved, but if for some reason there was a problem today, we're just going to stop the hearing and begin it again and send a new link out. So we think that should work. But again, I think it's been working smoothly so far. The Chief Justice is participating by telephone. And Mr. LeBeau, if you identify yourself, please, and you begin your argument. You understand you have 5 minutes.
Yes, sir, I do.
And we'll give you a warning with 1 minute left to go, okay?
Great, thank you for that. Yep.
Okay, thank you. Okay, you may proceed, Mr. LeBeau.
Yes, thank you, Your Honor. My name is Tyler LeBeau. I am a self-represented party in this matter. We moved in March of 2024. Within 25 days of us moving into the property, it fell apart. We had a drop ceiling in the kitchen fall onto my wife. My daughter had just exited the door to close the door, didn't close all the way. My wife went over to finish closing it. The drop ceiling fell down on top of my wife. There was several code violations, 22 code violations in total for both units in the duplex. When we moved in, there were no working fire alarms, fire extinguishers, any kind of life safety suppression issues. They had, I'm sorry, it's just been a year and a half of dealing with this, and it's been a nightmare for us. I had stuff prepared and I had a script prepared to read for you guys, but I'm taken aback a little bit as to why we're here still. I just got the notification that my motion that I submitted the other day was denied because it's not it's new issues, but I argue that it is a continuation of all of the issues that have already been discussed at length. Ms. McCurley was made aware at the end of March of last year of 2024 of all of these issues, and all of the issues that we're talking about that are within my defendant's exhibit binder. All of these issues are not overnight issues. All of these issues are a result of a long-standing neglect that has happened in this building. And I disagreed with the trial court's ruling as they didn't really weigh the accumulation of all of the events that we have. This has never been about living here for free. This has never been about trying to get a discount on rent. This has been a father trying to secure safe and habitable housing for his family. My son has had his leg fall through heating vents that are in the floor upstairs. My wife has fallen outside several times because we never had railings on the deck. And while Miss McCurley has done some of these little side projects, it's only done after something has had a critical failure. As my motion earlier today stated, that the plumbing continued to fail even as more than it did. There were structural support issues downstairs in the basement that was causing the dining room floor to sink and start to collapse in on itself. All of these issues are issues that were brought up during the trial. All of these issues were brought up to Ms. McCurley throughout the last year and a half. A year and a half into this, I still don't have a thermostat to access or control any of my heat. And now I really don't have access to it because Ms. McCurley evicted the neighbor next door, which is where the thermostat is. So now there's an unoccupied unit next door controlling the thermostat for heat control. This has been an issue since before we moved in, a known issue, something that it has not been contested by Ms. McCurley at all, and the record will prove that. I believe that the court weighed her testimony over mine and kind of put more weight into the not full work that was ever really completed. I'm a military veteran. I'm a community member. I'm a first responder in the community. This has a broader implication of issues, and I feel like as a tenant, I've never been about the money piece of this. I have always paid.
Mr. LeBeau, you have 1 minute remaining.
Yes, thank you, Your Honor.
Thank you.
I have always paid. I have always upheld my responsibility of being a tenant. As soon as the order came down from the judge to pay, I haven't missed a single payment. I have upheld my responsibilities. Miss McCurley has failed to uphold hers as a landlord. Even a year and a half into this, work has only been done after critical failures and it becomes an emergency repair. We've had several leaks. We have had several issues. Any work that is even being scheduled now is all work that should have been done prior to now. However, it's just been pushed along by Ms. McCurley. And I respectfully ask that the court reverse the trial court's decision just based off of the issues that are happening and continue to keep happening. And if the law states that a landlord is not allowed to rent a uninhabitable unit, then
Mr.
this
LeBeau,
judgment
you need
doesn't
to
stand.
finish. You can just finish up your last sentence or last thought, and then your time is expired. Okay.
I am all set. Thank you, Your Honors.
All right. Thank you, Mr. LeBeau. And we'll hear from the appellee. Identify yourself and identify your client, please.
My name is Justin Scoville, and I am representing the appellee Elizabeth McCurley. Can you hear me okay, Your Honors?
Yes, I can. I
Okay,
can hear you
thank
fine. You may begin.
Okay. To begin with, this appeal is from a lower court, and the appeal is about appealing a judgment and possession in favor of the appellee Elizabeth McCurley. Appellant identified a number of ways that they disagreed with the lower court's ruling. However, according to Vermont precedent and this court's rules of civil procedure, witness determinations, including credibility determinations, are allowed to be made by the lower court. And this is something that is given deference to the lower court by this court. But
it's under a clearly erroneous standard, is it not?
Correct, Your Honor. It's the clearly erroneous standard applies in this case, which is VRCP 52A2. And in this case, for factual determinations and for credibility determinations, it should be judged by the clearly erroneous standard.
I just have a question regarding the heating situation at the unit. It's a duplex, and there's a question involving adequacy of heat, which makes habitability in Vermont certainly an issue. And so, what do you want to say about the heating circumstances at the unit?
I believe Mr. LeBeau claimed the heating circumstances occurred. I think it was after he moved in closely in February, and then he also claimed that the heating circumstances occurred also later as well in the year. And at that time, the lower court allowed Mr. LeBeau to withhold rent during that period. And in final judgment, the court allowed Mr. LeBeau to withhold the entirety of the rent throughout that period that he claimed that what the court claimed was winter months. And the court allowed Mr. LeBeau to reduce his overall damages to Ms. McCurley by the amount of the withheld rent.
Thank you.
So in this case, the court properly took evidence. They properly admitted the evidence at trial, and they cited that evidence in the final order, justifying its determinations in favor of Ms. McCurley. They also discussed, the lower court also discussed in the final order why they viewed Mr. LeBeau as being less than credible. And these are completely appropriate. According to VRCP 52A2, due regard shall be given to the opportunity of the trial court to judge the credibility of the witnesses and the weight of the evidence. And when the evidence is conflicting, the credibility of the witnesses, the weight of the evidence, and its persuasive effect are questions for the trier of fact. Its determination must stand if supported by credible evidence. And so Mr. LeBeau also cites that the court misapplied 9 VSA 4457 and 4458. However, Mr. LeBeau, while he does cite one part of the statute, he ignores the other part of the statute, which says that reasonable amount of heat should be applied for habitability concerns. And the court, I think, properly adjudicated that.
Mr. Chalbault, you have 1 minute remaining.
Thank you. And so in conclusion, I believe that this court should affirm the lower court's ruling and should find in favor of appellee Elizabeth McCurley and allow the trial court's decision to stand on its own. Thank you, Your Honors.
Thank you. And bailiff, does the appellant have any time remaining?
Appellant has no time remaining.
Would you call the conclusion of the case, please?
The next hearing for the court is scheduled for 10:30 this morning.
Thank you both very much. We'll take this under advisement and issue a decision. Anything else from the Chief Justice or Justice Waples?
Thank you, Justice. Thank you very